Multiple offers are still very much a thing in Ontario. They were very common a few years ago, and while the market has softened, there are still plenty of properties, especially in Toronto, where buyers are still dealing with competing offer situations. Now, I've spent my career first as a realtor and now as a real estate lawyer, and there are always questions about the legal requirements and obligations that exist when a buyer is competing in a multiple offer situation. If you're going through the process right now, or you've ever lost a bidding war and wondered what was actually going on behind the scenes, this video is for you because there is specific information that you're legally entitled to have. My name is Soccio-Marandola. I'm a lawyer here in Toronto, and I help people like you close real estate deals every single day. Now, if you enjoy this type of content, make sure you subscribe and join our community. And if you have a closing coming up, we've built the most transparent legal fee calculator online. It gives you a full breakdown of every dollar you'll spend and even calculates closing costs like land transfer tax and title insurance. That's linked in the description down below. So let's start with the first and most basic requirement, the number of competing offers. Under Section 22.7 of the General Regulations of Ontario's Trust and Real Estate Services Act, that's the act where most of the guiding legislation comes from for realtors in Ontario, if a listing brokerage receives competing written offers, they're legally required to communicate the number of those offers to every person who is making one. So in plain English, if you're sitting at a table making an offer, your agent must be told how many other offers there are on that property, and that information has to be passed along to you. Now this sounds simple, but think about how many buyers have gone into their offer night with no idea whether they're competing against one other offer or 6. That uncertainty changes everything: your price, your conditions, your strategy. There is a requirement that says you don't have to guess. The listing agent is required to tell every buyer's agent the number of competing offers on that property. That is a legal obligation for realtors, not a courtesy. Now, the most common follow-up question I get on that point is, well, what happens if that number changes? So you submitted your offer where there were 2 other competing offers and a 6 o'clock deadline, and as you got closer to that time, the listing agent comes back and says, actually, there are now 6 other offers on the table. Does that entitle you to go back and revise your offer? So within the legislation, there's no legal entitlement for an offer revision or improvement. Any practice of that is merely a courtesy of the seller. While it may be in their best interest to allow for it, there are situations where it doesn't happen and buyers are left frustrated, which means you need to either put your best foot forward on your original offer, or be strategic about the delivery of your offer, which means you need to either put your best offer forward on the original submission, or be strategic about the delivery of your offer until you know the final number. Remember, offers are still subject to irrevocability, meaning you can't withdraw them and they remain open for acceptance until the time you've indicated on the offer. The second requirement is the commission conflict disclosure. Now, this one is one that doesn't get talked about enough. Under Section 23.4 of those same regulations, if a brokerage has entered into a representation agreement with the seller, and that agreement contains terms around remuneration, meaning commission, that could affect which offer gets accepted, the brokerage must disclose the existence of those terms and the details of those terms to any person who makes a written offer. And that disclosure has to happen as soon as possible after the offer is made and before any offer is accepted. So what does that actually mean in practice? Well, here's a scenario. The listing agent is also representing one of the buyers, so multiple representation. Now, it's possible that the brokerage has a deal with the seller where their commission changes depending on which offer gets accepted. A common example is that the listing brokerage may reduce their commission from the originally agreed upon total if their own buyer's offer is accepted. So instead of charging a seller 5%, they may have an agreement that says commission is reduced to a total of 4% if they also represent the buyer. Now, the legislation says every other buyer competing on that property is entitled to know that that agreement exists and the details of it. And this is done to even the playing field. For example, if you offered $900,000 and another buyer also offered $900,000, but that offer resulted in 1% less commission for the seller would be more inclined to accept that offer, even though you both offered to pay the same amount of money. You need to know that that exists in order to adjust your offer accordingly. And that can come in the form of your realtor reducing their cooperating commission, or you increasing your price to make it comparable for net dollars to the seller. So if you're ever in a multiple offer situation and you find out that the listing agent is also representing one of the buyers, your agent should be proactive in inquiring as to whether any commission arrangements exist that needs to be disclosed. That is your right. Lastly, we're going to talk about the content disclosure, and of course the clause that kills it. So this third one is where things really get interesting. So under Section 22.7.1b, a seller has the option, if they choose, to direct their listing agent to share the substance of the competing offers with every buyer who is making one. So in theory, a seller can say, I want everyone to know what's on the table, share the prices of all the offers, essentially creating an open bidding situation. and the listing agent would be required to do exactly that. The act even says the seller can choose to share only parts of the offer, not necessarily everything. However, any information that would identify the person making the offer cannot be shared, so identity is still always protected. Now, this option has been around for some time, but at least in my experience, it's very rarely used. In fact, I will often see a clause in buyer's offers that say if the seller discloses the whole or any part of the details or content of this offer prior to acceptance, the buyer has the right to immediately revoke their offer and have their full deposit returned in full. This is the buyer's way of opting out of that situation if they want their offer to remain private. And when the new legislation for realtors was updated in the last few years, we were coming off of the craziness of multiple offers, and transparent bidding was something that was seriously considered. And now it's just something that in practice seems to have not really taken off. So to bring it all together, in multiple offer situations in Ontario, you're legally entitled to know the number of competing offers, you're entitled to know if commission conflicts exist that could affect which offer gets accepted, and while sellers technically have the right to share offer details, that right is rarely used, and it's often contractually removed by the buyers. Know your rights before you compete. If you're enjoying these behind the scenes real estate law videos, make sure you subscribe to the channel. I post a new video every week. And if you're a realtor, I also send a weekly update about different legal situations that come up in our closings. That's our realtor newsletter, and you can subscribe to it with the link down in the description. Thanks for watching.